Good afternoon, everyone. Being how it is 2 o'clock, I will call to order the January 16th meeting of the Development Waiver Review Committee for Paulding County. My name is Ann Lippman. I am the Community Development Director, and I am the chairperson of this committee. Anyone who comes up to the podium to speak, please direct all of your comments or questions directly to me. And at this time, before we get started on today's agenda, I will ask my fellow members of this committee to turn on their microphones and introduce themselves, starting to my right.
My name is Jason Phillips. I'm the county attorney. I am not a member of this board, but I'm here as legal counsel.
Ray Wooten, Director of Water.
George Jones, Director, Paulding County Department of Transportation.
Bruce Coyle, County Engineer.
Frank Baker, County Manager.
Thank you all. Our first agenda item today is review of minutes from the December 19th, 2023 meeting. If everyone has had a chance to look at those, I will ask for a motion on those.
Motion to approve.
Second.
We have a motion to approve made by Mr. Jones and seconded by Mr. Coyle. Are there any questions? If not, I will call for a vote. All those in favor signify by saying aye.
Aye.
Any opposed? There are none. The minutes are approved unanimously by a vote of 5-0. And at this time, we only have one other agenda item. I will ask everyone if they have any mobile devices to please turn those to silence or turn them off so as not to disturb our meeting. Our first case today is case 2024-1-W. It is an appeal. It is application by Bloom Parham LLP requesting an appeal pursuant to Paulding County Development Regulations, Section 14.5.1, subsection 3, with regard to a second lift station at Pine Hills Trail. Property is located in land lot 669 through 701, 740 to 741, 770 to 773, 812 to 816, 842 to 844, 884 to 885 in District 3, Section 3, located at 7 Hills Boulevard in Post 4. I will note for the record that we have, in community development, received several calls and emails with questions and concerns regarding this application. Is the applicant present? Yes. If you'd like to come up and please be mindful that we allocate 15 minutes for those speaking in favor and 15 minutes for any opposition. So.
Okay. I might use this right here. My name is Andrea Pearson from Bloom Parham, and I'm here on behalf of Walton, Georgia, LLC, the applicant. And as you know, that this appeal relates to the Pine Hill Trails subdivision, which is a single-family subdivision that's divided into 2 phases. The site plan that you have in front of you includes phase 1, which has 666 lots, which is serviced by Lift Station 1. And then phase 2, which is 502 lots serviced by the proposed second lift station for the subdivision. And we're here today to appeal the county's decision that phase 2 cannot be serviced by a second lift station for the property without taking another lift station offline elsewhere in the county. Phase 1 and lift station 1 are not at issue. All along, with respect to this project, sewer availability has been a primary concern for the development. The county and the property owners have known that sewer infrastructure must be constructed in order to get sewer to the property. And there have been years of approvals and agreements that contemplated the use of lift stations and designated how sewer service was to be provided to the property. And never once through the history of the project did the county require that a second lift station elsewhere in the county be taken offline in order to have a second lift station for the project. And I'm kind of calling this the lift station policy as sort of a shorthand. And so it's our position that the county cannot now impose this requirement on the project at this point. Being able to use a second lift station is critical for phase 2 of the project. Due to the topography of the property, the phase 2 cannot be developed without a second lift station. With respect to the history of the project, I think some of that is important here. Essentially half of the property was rezoned in January of 2005. It was 326 acres rezoned from R2 to PRD to allow for 941 lots. And the conditions of that rezoning expressly discussed the sewer infrastructure for the project. It set out the specifics for how sewer service could be accomplished at the property, and expressly contemplated the use of lift stations for the project. And it also set out that a development agreement would need to be entered into between the property owners and the county to effectuate the sewer improvements. Again, sewer infrastructure was at the forefront of the development, but the rezoning conditions did not include the lift station policy as a condition of rezoning. If you look at the conditions themselves, they contemplate the use of lift stations. For example, condition number 3 expressly discusses the possibility of having lift station lots for the project. It also talks about if there are lift stations, what the specific requirements for those lift stations would be. Therefore, if lift stations weren't permitted, they would not have specified what the requirements were. It also discusses in condition 21 that the owner developer shall enter into a development agreement with the Paulding County Board of Commissioners to participate in the required off-site sewer system infrastructure needed for the proposed development. So again, they're contemplating a development agreement to set out how sewer infrastructure is going to be implemented for this project. And that development agreement was entered into in November of 2019. That's Exhibit 4 in our Notice of Appeal letter. So again, pursuant to rezoning condition 21, that agreement specifically set forth the required off-site sewer system infrastructure for the project. And that agreement set out that the parties agreed to eliminate the Possum Creek lift station. They also agreed to construct the Possum Creek gap sewer as set forth in the agreement, which was 8,700 feet of 18-inch diameter gravity sewer. The landowner was responsible for certain aspects of the project, like surveying, easements, permitting, and the county agreed to contribute to the cost of construction approximately $1 million, and the landowner would be responsible for any costs over that amount. The development agreement expressly states that that agreement sets forth the full and complete agreement of the parties concerning the subject matter, and it could not be altered or amended without the express written consent of the parties. So the development agreement itself states what the off-site sewer infrastructure is required for the project, which was to take the Possum Creek lift station offline and construct the Possum Creek gap sewer. If another lift station was required to be taken offline elsewhere in the county, it would have provided that in the development agreement. And again, the development agreement is the entire agreement for the parties, and the county is not permitted to impose new requirements now. The county entered into another development agreement in 2020 related to roads, but one of those provisions is notable because it references the November 2019 development agreement for gap sewer. It says also known as the Possum Creek gap sewer improvements, attached here to as Exhibit 1. And then that development agreement says which agreement ensures the provision of sewer to the property. So in that second development agreement, the county is acknowledging that the sewer development agreement from 2019 ensured the provision of sewer service to the property and to the project. And then again, the portions of the property were rezoned in 2021. 355 acres were rezoned from R2 to MPR, which permitted 710 single-family lots for that portion of the project. And again, that rezoning condition included an acknowledgement that sewer availability is the subject of a development agreement with Paulding County November 12, 2019. So it again is acknowledging that that sewer development agreement applies to the second half of the property. And I believe there's actually a line delineating those two rezonings in the site plan in front of you. And I also think it's worth noting that the rezonings permitted up to 1,651 lots. And that site plan only includes 1,168 lots, so it's a lower density than what is actually permitted or could be developed pursuant to those rezonings. In December of 2022, however, The parties learned from the county that they were going to be implementing the lift station policy, thereby prohibiting development of phase 2 of the property unless Walton agreed to take another lift station offline elsewhere in the county in exchange for building this new lift station. We received a final decision from Mr. Phillips in September of 2023, which we appealed in October of 2023, which is why we are here today. And we believe that this lift station policy cannot be imposed with respect to this project for a number of reasons. First of all, we believe that it violates the development agreement. The development agreement specifically set forth what the required offsite sewer improvements were for the project, and it's the entire agreement between the parties with regard to those improvements. And we don't believe that the county can require Walton to take another lift station offline that's not set forth in the development agreement. Secondly, we believe that the county's regulations themselves expressly permit lift stations. The county has very extensive requirements in section 7.219 of the development regulations that set out rules for the site requirements, design features, et cetera, as I know you guys are much more familiar than I am with those requirements, but it doesn't state anything with regard to the county's lift station policy. It's not included anywhere in the county's written and objective development regulations. So if a lift station satisfies the requirements set forth in the county code, it is permitted under the code. Where an express provision in the code provides that lift stations are allowed, the lift station cannot be prohibited based on an unwritten, uncodified policy from the county. We also understand that Mr. Phillips, in his letter, relied on a different provision of the county's regulations in section 66131, which is acceptance by the county of sewer lines. And it says that basically the design specifications, route, and materials utilized in the construction and installation of the sewer lines must be approved by the director of water systems or his representatives prior to construction of the sewer line. Again, this doesn't say anything about prohibiting lift stations. This is a general provision related to the approval, but if this code section prohibited lift station, we believe it's void for vagueness because the county's other regulations specifically set out what and when lift stations are permitted. And if a objectively proper lift station is submitted to the county, we believe that those regulations set out and specify what, when those are allowed, and that the county cannot rely on a more general and ambiguous provision to deny a second lift station. And we also believe that this county policy kind of has the danger of giving the county unfettered discretion to decide when a lift station has to be taken offline in order to get a second or another lift station. We believe that not having any objective criteria or setting that policy out in writing is problematic under due process law in Georgia. Parties have to have, or policies have to be written with sufficient specificity to appraise all parties concerning the prohibited conduct and required conditions. So somebody coming into the county to do business needs to be able to understand objectively what they have to do to get what they're asking for. And we believe that the county's unwritten and uncodified lift station policy violates those principles under Georgia law. We also believe that Walton has vested rights in approval of the second lift station. Under Georgia law, if a landowner makes a substantial change in position by expenditures and reliance on the probability of issuance of a permit based on existing zoning and the assurances of zoning officials, he can acquire vested rights and be entitled to the permit. We believe that the development regulations, as well as the development agreement itself, provide those assurances under both the contract and the county's rules, setting out when and what should be permitted, and Walton relied on the development agreement and the development regulations and believing that they would be able to develop this property using the second lift station. They purchased the property for several $1 million and have spent over $600,000 in pursuit of the development and management expenses with the understanding that they would be able to develop the entirety of the property, including phase 2. There's additional builders working to develop this property, have actually spent even additional money over and above what Walton has spent. And all of this was done in reliance on the zoning, the development agreement, the county's rules as assurances that the project would be able to be developed with a second lift station. And it really comes down to asking, why would the parties have agreed to the development agreement if they didn't think that that provided them with sewer service to the property? They're going to be spending millions of dollars to implement that agreement, and it really doesn't make sense to agree to that if they're not able to actually get sewer service to the property. The money expended doesn't make sense if they can't develop half of the project. And we also believe that there's another, I guess, legality issue with respect to the lift station policy, and then it is an illegal exaction. We think that the county is trying to force the developer to pay for infrastructure improvements elsewhere in the county that have no nexus to the proposed or to the impact of the project on the county. So taking the lift station offline elsewhere doesn't relate to the proposed impact of the subdivision and is actually trying to get Walton to make a system rather than project improvement. So we think really what we are seeking here is a workable solution. We know that the parties have gone back and forth with the county on this issue, and very competent professionals have been working to try to find a solution. Everyone has been working with the county diligently for this, and we understand that and believe that the tax benefits for the project would easily compensate for the county's concern with respect to the cost per year of maintaining the lift station. And we think that the parties have already reached agreement through the development agreement on what the requirements are for sewer infrastructure. We believe that the county, or we believe and propose that the county just agree to that solution, that the parties implement the development agreement, take the Possum Creek lift station online, construct the gap sewer, and allow phase 2 to proceed using a second lift station. That is what we would ask for y'all to consider.
Okay, thank you. I was about to stop you because you just hit the 15-minute mark. So
Right at it.
but that does not leave time unless the committee votes to allow others who may want to speak in favor of it. So we'll get to that point when we get to it. We'll start. If you'd like to, Ms. Pearson, if you'd like to stay up there. At this point, I'm going to see if anyone on the committee has any questions for you. This will not count against your time or any time for it. Microphone.
If I could ask a question. When y'all purchased this was part of the agreement you're talking about that deal with the gap sewer. Are you aware of a September 16th, 2019 letter from the director, Lori Ashmore, concerning the properties? If I could give you a copy, and if I could pass out a copy to the rest of the group. Everyone.
Jason, can I ask, is this something?
Yeah, Mr. Wooten, you want this to be part of the record in this case?
Yeah, could
Okay.
I make this part of the record? And this was in part of the agreement for the property. In the paragraph number 1 at the bottom of the page, it says that, there's a fully designed gravity sewer line known as the Pumpkin Vine Outfall Line. I believe easements were in place to build that, and it says this solution on the last line is still available and has been available since 2008. If you could flip over to the next page to item number 4, it says, we we, not being me, it's the director prior to me, we discussed that an existing lift station would be eliminated, benefiting the county due to the installation of the gap sewer. This would save the county significant dollars in maintenance issues. For a single pump station, the power can be over $2,500, and that's a month. You can also be responsible for replacing pumps every 4 to 5 years. There's a great maintenance cost that's involved in every pump station that's done. So developers can't just put in a pump station because you are putting the burden on our ratepayers to pay for the annual maintenance in perpetuity for this pump station. Another question I had, a development drawing was submitted. Let me look in the.
Mr. Wood, before you go to your next question, did you have a question of Ms. Pearson?
Yeah, so first of all, I'd just like to note for the record, we have never seen this before. I, don't necessarily know or agree. It's dated September 2019, which is, September 2019 is actually before the development agreement. So to the extent there are any agreements or requirements in here different or inconsistent with the development agreement, I would say that the development agreement would supersede those. Again, this is a
Okay.
3 to 4 page document that I've never seen and not had the
Okay,
ability
well,
to
that's-
analyze.
That's why I provided the document.
Okay, yeah.
And Ms.
But,
Pearson, just for the sake of clarifying the record, Mr. Wooten and Ms. Pearson are referring to a September 16th, 2019 dated record on Pine Hill Investments Incorporated letterhead to Ms. Lori Ashmore, and it is signed by W. Barrett Howell II, Pine Hill Investments, Inc.
and I guess with respect to your second point, the concern about the maintenance costs, again, Paulding County's regulations expressly permit lift stations. Objectively, lift stations are allowed in the county. If the county has concerns regarding those lift stations, at this point, they haven't done anything to change that, and we are here asking for something that is currently expressly permitted by the regulations. So that would be my response to the concerns regarding cost for a lift station that your regulations allow.
If permitted, what I'm saying is you're asking a developer to be allowed to impose a cost upon ratepayers in perpetuity. The reason that we're very objective about when we approve pump stations and we try to review them is so that in part of the development, another drawing was submitted with a note on it that multiple pump stations may be needed due to topographic concerns. And basically saying the property may not be limited to 2. And that was presented in a LDP meeting on this property when I said I would not support a second pump station. But I think based on what information you've given, to give you time to read and review this and for everybody else to come up to date, would be, should we propose tabling maybe?
Whether y'all table or not, you can make that decision when everybody's had a chance to speak.
Okay, well, I'm just asking for you to have time to review this and understand this.
Understood. And I think we would be, I would have to confer before agreeing to that, but I think that would be agreeable, just because I have not seen this before.
Okay. I've had to do research to find out more information on this project that was basically put together before I was in the position I'm in.
Okay. And I guess on the issue of multiple lift stations, it is my understanding that, this is the site plan that we have presented to you all, and it is the site plan that I understand the parties are currently proceeding under, and it only has 2. So as far as I'm aware, the possibility of additional lift stations it's not something I'm aware of.
Can you read line 6 from what you've submitted? It says, due to the extreme topographic elements, multiple lift stations are required for this development. And that is on what you've submitted with your package.
Correct, and I believe that multiple lift stations is referencing that there's more than one, and there's only 2 shown on this site plan. So, I don't believe that was, the site plan is showing what is intended currently for the property, so.
But it's not what it says.
Again, I think multiple just means more than one. So, it could say, I don't think that's intended to encompass more than 2 that are shown depicted on the site plan, which is what we submitted with our application.
Mr. Wooten, just to clarify the record further, can you identify the document that you directed Ms. Pearson to when you referred to what, line 6? What document is that?
If you look on the very last page, it's not the, it's the one, hang on.
The site plan required to be submitted with the application.
Correct. It's the sheet that we have on board.
What's the name of the sheet?
The official name. And what?
I mean, the title, D.R. Horton, Inc., and Title Resources Project Pine Hills Trail Subdivision. It doesn't have a title.
Sheet S-1.0.
That should suffice.
Yeah, CS-1.0 is down at the bottom. Concept site plan for CS-1.0.
So in the definition of multiple means 2. If multiple is 2 or are we redefining multiple?
I think Ms. Pearson said more than one.
Right, which, yes, perhaps that is not as specific language as could have been used, but I would say that the site plan itself shows the intended lift stations, which is only 2. That's all I can, I can admit
Okay.
that while we're standing here.
Okay, well, I'm referring to the
Okay.
language directly on the site plan. So, are there any other questions?
I have another question. You referenced in your initial presentation, our numbers are a little off. I also did some calculations, the combination of the 2, the PRT rezoning and the MPR rezoning. I came up with a total of 1,663 lots. The site plan that we have on the screen that was submitted with this waiver shows 1,157 lots. The Community Development Division has also received a concept plan for review and discussion by our Development Control Committee showing 1,145 lots. In your applications, I guess the hardship that you state, and I'm going to read directly, the county's decision eviscerates the intended use of the property as 537 lots will be lost if Walton cannot use a second lift station. Is this taking into account the 506 lots that have already been reduced by this revised site plan?
No, and to clarify, that was a number submitted before this most updated site plan. So that number is referencing it should be now the 502 phase 2 lots.
The ones in pod. So you're saying that pod B2, pod I, pod J, and pod K could not be developed?
Correct.
Okay.
So those are the ones that are, if you see the pink kind of dashed line, those are the phase lines. So I guess to the north of those are the lots that I'm referencing, because those are the ones that are proposed to be serviced by the second lift station.
Okay.
So the most updated number, as far as is my understanding, is it's phase 2. The loss would be of 502 phase 2 lots.
Understood.
Yes.
So, okay, well, then that begs the question of, compared to the initial, let's just make the math simple, the 1,600 plus lots down to 1,157, where did those 506, what happened to those 506 lots? Is that something that you can answer?
My understanding is that they just didn't propose as dense of a development as what was permitted by the rezoning. So my point in making that is the proposed project has less lots than could have been allowed under the two different rezonings.
Understood, but is there a reason? Did they just want to do less density? What is the reason for reducing the lots by 500 even before the lift station situation came into play?
I don't know the answer to that
Okay.
question.
Okay. Does anybody else on the committee have any questions?
I have a comment for clarification.
Okay.
No questions, but just a clarification. Ms. Pearson mentioned during her opening statement that I, as the county attorney, had rendered a decision as to their request to have a second lift station. I, as the county attorney, do not have decision-making authority. I was merely responding to an email that Mr. Bloom had sent me asking me to look into a situation, at which time I consult with my county clients and I conveyed to Mr. Bloom the position of my clients. Just to be clear, I am not a decision maker in that regard.
Fair enough, and that was maybe shorthand for referring to your email, so understood.
Thank you, Mr. Phillips. Are there any other questions?
Yes. So apparently phase one is the south end of this property and number one lift station. Where was it going to pump to? Do you know where it was going to discharge?
So I believe that it is set forth in the development agreement. So through the, it is going to, through the Possum Creek Gap Sewer,
Yeah, I think it shows
Yeah,
the
it's-
discharge manhole on this document here. And it goes to Possum Creek, and so the sewer agreement was upgrade or outfall Possum Creek lift station. And therefore yours could go in, pump to that 12-inch. I'm just wondering, or what was the intention? Were you gonna pump north, but you've got to still build lift station number 2? And lift station number 2 was gonna pump to, I'm just curious of the schematic of this system.
So my understanding is lift station number 2 needs to pump to 1 so that it could then go to the gap sewer where
Yeah.
they're going to replace
And-
to go south.
Have they explored what happens when these 1,100 lots hit Possum Creek lift station? Is there a plan? I think that's why they were looking at an outfall. Otherwise, you'd have a serious major improvement to Possum Creek lift station
So I
for
believe
capacity purposes.
they're going to be, as part of the agreement, eliminating the Possum Creek lift station to construct the gap sewer to allow, so the Possum Creek lift station would be eliminated
And
by this agreement.
by this agreement and your developers.
Correct, because the gap sewer, the gap is going to be constructed as part of the
But
development.
I thought you were arguing earlier that you didn't need to mess with Possum Creek lift station.
No,
That's
I'm just, that is the lift station that I understand is going to be taken offline. The fact the county is requiring an additional lift station be taken offline to get lift station 2 for this project. So that is what we are contesting, is that we should not be required to take offline unidentified lift station number 2 elsewhere in the county as part of getting the second lift station for this project, because the parties have already agreed how the sewer is going to be provided for the project through the development agreement.
So the agreement was to pull Possum Creek lift station out of service with a joint venture project with Paulding County to outfall that, So you were essentially removing one lift station and bringing back not two, but one additional to what was there.
Well, so, yeah, our argument would be that because the development agreement identified which lift station needed to be taken offline for the project, period. That was Possum Creek, and that the gap sewer would need to be constructed, and that is how we would be able to be permitted to obtain the sewer service for our property, and we should be able to use 2 lift stations for the project, because only Possum Creek was identified as the lift station we needed to take offline. An additional lift station
So
wasn't
you were
mentioned.
agreeing to take one out,
Correct.
but you're still adding, you still have to have 2 to service your project.
Correct.
Any other questions? Mr. Phillips, at this time, the time that we typically allocate for those wishing to speak on behalf has been used up. Do we need to extend time if there's anyone else who wants to speak in favor, or?
Yeah, I would recommend that you take that up.
Okay. Would anyone like to make a motion to extend time to speak in favor?
I'll make a motion to extend time.
Do you have a time that you'd like to extend?
Next meeting. Next meeting.
Make it 5 minutes. I recommend 5 minutes.
Okay. Do I have a second?
Second.
Okay, a motion by Mr. Baker, seconded by Mr. Jones to extend time to speak in favor of this application by 5 minutes. So I will ask, is there anyone in the audience who would like to speak in favor of this application? If you would like to come forward. Looks like we did not need our 5 minutes. I will move on. Is there anyone in the audience who would like to express opposition or has questions or concerns regarding the application? If they would like to come up. Appears there are none. So I will close the public hearing portion of this, and I will ask for any questions or additional discussion from the board, or if anyone would like to make a motion.
I'd like to make a motion to table this, to give them a chance to read the information we provided and for us to process the information they gave us.
I'll second.
Okay, we have a motion made by Mr. Wooten, seconded by Mr. Baker to table this. Would this be tabling it to our next meeting, which is February 20th, 2024?
Yes.
Okay. Since we have a motion and a second, I will call the vote. All those in favor of tabling for 1 month or until February 20th, 2024, please signify by saying aye.
Aye.
Any opposed? There are none. We have made a unanimous vote to table consideration of this item until February 20th, 2024. That is our only agenda item today, so I will ask for a motion to adjourn.
Motion to adjourn.
Second.
Have a motion made by Mr. Baker, seconded by Mr. Wooten to adjourn. All those in favor signify by saying aye.
Aye.
Thank you. We are adjourned.